All right, guys, welcome to this episode of the Street Cop Podcast with Zach Miller. As usual, we have some questions this week that we're going to explore and discuss some case law. I haven't done much preparation. I don't think Zach has much either, but we have general knowledge. You haven't done much preparation, right? Listen, we're really going into the depth of there isn't many conversations that really need a lot of in-depth research, especially when we're talking about the kind of situations and circumstances that are being volleyed our way. It's just maybe just a continued, and again, I'm going to just parlay it off onto you. It's a continued study of the craft. Even when I'm doing research on out-of-state cases and case law, to see if it varies from the Supreme Court of the United States and Fourth Amendment. In some states, a little bit does here and there. But, overall, we're still citing U.S. Supreme Court case law. So I'm still always reading and actually understanding more about it, seeing things I've never seen before. I'm like, oh, that's interesting. And then I'll dig into that case and read that. And I'm like, oh, okay. And then I'll kind of do a little research to make sure that still has been overruled or overturned. And, and that's where I'll have my answers. So you're like, man, you're really good at answering a lot of legal questions. Yeah, I read it a lot, So without further ado, here's Zach Miller, the Lord, our Savior in law enforcement case law advisory. How are you, buddy?
Thank you.
You're welcome.
Thank you. I'm doing well.
As usual.
Seems like we were here just the other day. Back again.
All right. So you want me to ask the question? Or are you ready for the question?
Yeah, you can go ahead with the question. I got a couple things I'll talk about, but we can do questions first.
Okay. So this one came in from, it's blocking me, but here's that K9 one. Guy writes them and says, I have some case law questions in regards to use of police canines. Who should I email? It's funny. A lot of people ask me in class, especially canine handlers, like, hey, are you guys doing canine course? Regarding case law, there really isn't much case law to discuss when it comes to a canine. Here's why. Most of the stuff regarding a canine had to do with essentially other issues. Would you agree with that? Like seizure issues, not the actual dog itself.
Yeah, it's really, there's not a whole lot. I mean, it's well established that the use of the dog is not really the legal issue. It's what you do after the dog alerts to something and whether it's probable cause. And there's case law about training records and that kind of stuff. But yeah, there really isn't a whole lot of nuance to dog case law.
Yeah, even if you look into some of the stuff that had to do with the dog, it really didn't have to do with the dog itself.
Yeah, you
it
can
had
take
to
the
do
dog out of the picture and it'd be the same thing. Yeah.
Yeah. All right, so I'm going to read this one. So I feel like I've read a lot of case law that contradicts each other, and I've heard two different answers. As far as using a police canine to sniff a vehicle on private property versus parking lot versus a suspicious vehicle occupied, parked not on the roadway, etc., when is it acceptable to search after a canine indication, and when is it not okay to search without a search warrant? Since the search warrant exception only applies to vehicles that can be moved before a search warrant is obtained, correct? Right, inherent mobility. Okay, yep, we're there with that one. I'm a canine handler, and I'm really looking for clarity and the answers so that I can prove the right way to my unit and fellow officers and continue to train that into future handlers. Okay, so that's the answer.
Okay.
That's the question. I'm sorry, Mike.
Question. So I guess the first, we kind of already covered the do I need a warrant part already. I mean, if it's a vehicle, and again, this is the Fourth Amendment answer. There could be a few states that may require a search warrant, but if you're in a position to deploy your dog around the vehicle, assuming you're lawfully in that position to begin with, wherever the vehicle is parked, if you're allowed to be right there to walk the dog, and the dog alerts to the vehicle, and you have the requisite training to show how reliable he is, at least for purposes of probable cause, then you can search it without a warrant. The dog is essentially telling you you've got now probable cause to believe there are narcotics or drugs or illegal substances in that vehicle. You don't need a search warrant under the automobile exception. The inherent mobility of the vehicle, not the actual mobility of the vehicle or the potential mobility of the vehicle, that's not what triggers the automobile exception. It's the fact that vehicles are by their nature mobile, and also coupled with the reduced expectation of privacy in vehicles. That's what justifies the search without a warrant. We don't have to show that there's any associated time-sensitive exigency. So it could be an unoccupied vehicle that your dog alerts to. You can search it without a warrant under the automobile exception with the probable cause provided by the dog.
When we talk about inherent mobility, would we be correct in understanding that a car that has no engine is probably not going to fall under the automobile exception. Make it very clear.
Yes, that's where we've moved beyond inherent mobility. No engine, no wheels on the vehicle.
Yeah.
Then you're probably going to need a search warrant unless there is an actual exigency that you can point to, an actual sensitivity.
And you and I, just even on this topic, I'm going to ask you another question regarding this, because I know what this guy's asking his questions, what he really needs clarity on. We talked about a car that's crashed into a pole and now is no longer mobile. It's broken axles, the whole thing, tires deflated. This car will never drive again. Is that something that's going to fall into the automobile exception?
Generally, yeah, it does. The few cases that I've ever seen where that was the issue, where that was the sole basis for the search. We weren't towing it, so there's no inventory basis. It's solely the automobile exception. The court said, well, it was just recently being operated on the roadway, therefore the automobile exception still applies in that case. Yeah, so you search without a warrant.
And do you think that SCOTUS, if it ever made it, to me, that in my mind as we're having this conversation, that sounds like something that SCOTUS might hear or something like that, and might interpret it differently. So would you ever think that, and again, I'm just asking you, maybe that circumstance to ever err on the side of caution, I hate saying that word, but like, you think it's a scenario where it probably wouldn't hurt to get a warrant, maybe, or?
Well, so I guess two things. Let me talk about the if does it hurt to get a warrant, and then the SCOTUS issue. Supreme Court of the United States. Those of you who don't know what we're referring to, it never hurts to get a warrant. That's a true statement. It's never legally incorrect to get a search warrant. When it comes to searching cars and the automobile exception, my position on when a search warrant should be obtained and when you're unsure, it's when you're unsure of your probable cause. If you're questioning whether the facts that you have rise to the level of probable cause, then it would be wise to seek a search warrant from a judge or a magistrate to verify the existence of your probable cause. If you know you have probable cause and you're questioning whether this vehicle falls under the automobile exception to do it without a warrant, we've already established that probably 99% of the vehicles that you encounter are going to fall under the exception. So if the question is about the mobility of the vehicle, I don't really see any really good reason to go get a search warrant, because you're just spending time doing something you don't need to. But if you're questioning your existence of probable cause, that's when I think it would be appropriate to go to get a warrant.
Okay, cool.
All right. So as far as the Supreme Court revisiting the issue about the crash car, I'm inclined to think that there aren't a whole lot of points under the automobile exception that have left that are unexplored by the Supreme Court. They've been very clear in their almost 100 years of automobile exception jurisprudence that a warrant is just not required for searching cars when you have probable cause. We're left with these little unique fact situations like the one that you pointed out, the crashed car, the vehicle on curtilage, which I'll touch on in just a second. So I think the court would be pretty disinclined to revisit another automobile exception issue. They're definitely not going to overturn or change the course of the automobile exception. We got 100 years of case law supporting it.
Yeah.
So I doubt they would take that case.
As far as going, you said before, being in a legal place to sniff a car, essentially we're kind of discussing Illinois v. Cabayas a little bit. A dog sniff is not being a violation of the Fourth Amendment. So this free air sniff title that a lot of people misinterpret. So if you're looking to understand what a free air sniff is, Illinois v. Cabayas, 2015. Is it 2015 for Cabayas? 2011?
Rodriguez was 2015. Yeah. It was a little before that.
2011, I think Cabayas was Cabayas.
That sounds about right, yeah.
They discuss sniffing cars without reasonable suspicion. And again, some states say yes, a majority of states say that's fine. A minority, for example, Pennsylvania, you're not deploying a dog without reasonable suspicion in any circumstance. They're not allowed to do them. I want to say Minnesota as well. I could be wrong, but I haven't read it in a while. I've been there, and I'll be going there in August, and I'll have a better understanding of that when I get there. As far as being in a legal place now, we've established that you can use the dog. You can sniff without any prerequisite. When we talk about legal place, is a driveway a legal place?
With your dog, no. So here's where the distinction comes into. So the court has drawn a distinction between residential curtilage, and just private property, publicly accessible private property in general. So for example, a motel parking lot, that is clearly private property, but it's publicly accessible private property. And just as anyone who hasn't been expressly banned from that property, but anyone in general can just walk onto that parking lot, walk or drive onto that parking lot. And a police officer can do the same. And whether he has a dog with him or not, does not implicate the Fourth Amendment interests of the owner of the property, nor it clearly doesn't implicate the Fourth Amendment interest of the people visiting that property, the customers. But the court does draw a line at residential curtilage, a case out of 2013, Florida versus Jardinus, where the court held that merely bringing a drug dog onto residential curtilage, doesn't matter what part it is, the driveway, the front porch, or the side, backyard, doesn't matter. That act by itself is a search. Therefore, you would need either consent, a search warrant, or probable cause plus some kind of exigency in order to do that. Now, the officer can walk up the driveway to the front door without express consent, because there's that implied societal license that anyone can do that, walk up the front door, or front walkway and knock on the door. But by bringing a drug dog onto the scene, the court held in Jardinus that exceeds that societal license to enter curtilage. So no, you cannot just bring a dog on curtilage and sniff a car in a driveway, for example, without a warrant or an exigency or consent.
If you were walking up that driveway, let's talk about two different scenarios. The first one is maybe you get a tip. Hey, I think John on the corner in the red house is selling narcotics. And maybe as a police officer, you're just going to walk up on the driveway and walk to John's front door, knock on the door, and ask him about his, maybe listen, nobody's looking into it. I'm going to go there and patrol. It's a small agency. I'm going to go knock on the door and see if I see anything. As you walk up there, you look inside the car that's parked in the driveway, and through the window, you see a quantity of narcotics, illegal narcotics. Let's call it methamphetamine, an ounce of methamphetamine sitting on the floorboard of the car. Would you be authorized to search that vehicle?
Without a warrant?
Yeah.
Absolutely. Hands down.
Okay.
No question about it. Under the automobile exception. As long as it's an apparently operable vehicle. It's got four wheels on it, looks like a normal functioning car. Yes. I'm in a lawful position in this case. I'm allowed to be where I am on the driveway for the very reason you mentioned. Going to do a knock and talk for all intents and purposes. And I happen to see in the vehicle, as long as it's immediately apparent to be methamphetamine, then there's my probable cause. And I can search without a warrant. Don't need a search warrant.
What if you walked up? What if somebody said to you, hey, he leaves his drugs out in that car, right? I'm just letting you know. So if you walk up and look in that car in that driveway, you're going to see the drugs in there. And you walk up with that purpose to walk up and look inside the car. Is that a little different?
That is a little different. And that's going to cause some issues. We got Collins. I'll call it the Collins issue, Collins versus Virginia, where the court held that the entry onto residential curtilage for the sole purpose of conducting a search of the vehicle under the automobile exception violates the Fourth Amendment. Now, here we're going to get into the subjective state of mind of the officer. What is it the officer is intending to do? Is he intending to go on there for the purpose of searching the vehicle, or is he going on there for the purpose of just trying to verify the tip about the vehicle? There's an argument that we could make that. But in that case, we're going to be running into some issues about our lawful presence on the property. So
walking up and inadvertently seeing something is very different than walking up and purposely looking for something.
Yes, absolutely. An inadvertent discovery while we're lawfully there for some other reason, hands down, all day long, we can search that vehicle. It's the purpose for being on the property that is going to come into play. Yeah.
What if you get a good, reliable source of information who tells you, hey, there's a kilo in the trunk of that car, and the reliable source, I don't know, maybe not the most reliable, and I'm going to say this in one way, not enough to establish a probable cause to support a search warrant. And you are under the belief that, hey, we should really look into this. What do we do in that situation where time is a factor? We have somebody who we think maybe maybe is offering some real interesting facts. We have veracity, we have corroboration, and they say there's a kilo of cocaine in the trunk of that car in that driveway. Are you guys going to do something about it? Now what do we do? Besides the knock and talk, is there ever a time that we can, let's say we call a judge and say, the judge says, yeah, you look, I know what your source of information is. I don't think it's enough to support a warrant. Can we ever bring a dog on to sniff that car with that reasonable suspicion to try to go get a search warrant? You know?
I'm inclined to say, just kind of off the top of my head, I don't know. A search warrant to conduct a search, which the entry onto the property would be the search, is going to have to be based on probable cause. So our informant is going to have to establish probable cause, and you've already said that he doesn't. And I'm assuming maybe it's because he doesn't know. How does he know there's drugs in there? Yeah, so we would need probable cause to search the car already to be able to get the dog on the property with a warrant in that case. So it sounds like a knock and talk probably would be the only thing. With the dog, we have to leave the dog in the truck, on the side of the road.
Or I guess you just have to sit on the car and wait till the car leaves and then pull the car over.
Let him leave. Yeah, let him leave and pull him over, and then we're everybody's fair game then.
What if you're watching, let's say you got narcotics set up on the house and you're watching, the guy comes out and grabs a package out of the trunk. What do you do then? Like, oh shit, is that the kilo?
I could argue that, with the same tip that you just mentioned.
Yeah, the same tip. Hey, look, we're going to set up. Listen, the judge said our judge is a little weird. He doesn't like. He's a nervous Nelly. We're going to set up on his house and just watch this car. It sounds like a good job for this narcotics division. A kilogram is something we've never gotten before. And they send the guy out there. And he's sitting and watching. Yeah. And 2 hours later, a gentleman comes out, goes into the trunk, and grabs this package out, and starts walking inside. What do we got then?
I'd probably maybe an exigency. So I would try, and we need to get him before he goes into the house. I think we can definitely do a Terry stop on him on his driveway. And then going back to our tip, we probably have, it sounds like we've got probable cause to believe those are drugs. We're now lawfully on the property. We're on the property for purposes of conducting a Terry stop, not for searching the vehicle. Mm-hmm. So one, we can search that package without a warrant, probably under an exigency theory, and then we can now search the vehicle, I would think, for more drugs potentially. If he gets inside the house, we could argue perhaps a destruction of evidence type of an exigency that could forego a warrant requirement. But yeah, once that tip has confirmed to the level of probable cause by him bringing those drugs out of the vehicle, or what we suspect to be drugs, that changes the game a little bit. I don't know that we would really need a dog for anything, or our eyes are giving us the probable cause coupled with the tip. Yeah.
And this is important. This is why I say knowing sources of information is so important. Are we doing source information this week?
Yeah, we were. Well, we kind of talked about it beforehand. I mean, I can make some general comments about them.
Yeah, no worries. And then the last one I have is that one. This one's an interesting one. It says, "Hey Dennis, would you be willing to do a podcast segment on reasonable suspicion stops on pedestrians?" It says, "Thank you." When I said, what are you looking for clarity on? He goes, when dispatched or witness a suspicious activity, and when do you have enough reasonable suspicion to stop someone, demand identification, or further investigate the incident, totality of the circumstances? So what he's saying is when dispatched. So we go to sources information. That's really where it comes down to begin with. When dispatched, what does that mean? The number one question, in my opinion, and you could let me know what you think, is who is reporting it? I think it's where it all starts.
Yeah, absolutely. That's in a lot of what we do is we respond to people calling us and making some kind of allegation about what they see or hear, what they've been told. When it comes to just everyday people who report activity to the police, someone who calls 911 or calls the non-emergency number and makes some kind of accusation, we don't necessarily know who the person is. We may not have met this person before, but this is probably not going to be an anonymous person, because there's some kind of way to get in touch with this person. Usually if you call 911, your information is on the computer display there. At some point we could find out who this person was. And their courts consistently have held that we're allowed to believe whatever it is they're alleging is they're telling the truth. They're being truthful about what it is that they're saying. Now, whether what they're saying rises to the level of reasonable suspicion or probable cause, that's going to be based on the content of what they say, and then also their basis for knowledge. How do they know what it is they're alleging about this person? But believe it or not, we are allowed to believe people are telling us the truth, or at least the truth as they see it, when they call the police, unless we have a specific reason to question this particular person's credibility. And when I teach this block, I go through a long, probably hour-long discussion about this very topic in my classes. So
it's an important topic. Yeah, it's a very important topic. Are police officers under any obligation to kind of match up the findings to see if it's similar to what's been reported before they take an approach? What's the deal with that?
I mean, it depends on who your source is at first. If this is somebody who is a known, let's say the person that's reporting the allegation to us is a known criminal, or someone has a known criminal past. It's someone that we personally know. Yeah, we know in the past they've been involved in criminal activity, and we're aware of this fact. That kind of diminishes their reliability, at least on its face, to a degree. It reduces it slightly. They could certainly be telling us the truth now, but there probably is now a duty on us to at least corroborate some of what they're saying, because we know in the past this person has been involved in criminal activity, which at least calls into question their trustworthiness. Versus if the caller is an off-duty police officer and he or she tells us, hey, I'm off duty, this is what I see. There is a strong presumption that person's telling the truth as to what they're observing. And we probably don't need to corroborate anything if the content of their tip rises to the level of PC or RS.
Would you say it's a good idea to train dispatchers to develop as many facts as they possibly can before the police get there?
Absolutely. I mean, how do you know what it is you're telling us? These are things I'd want a dispatcher to ask. Okay, I hear what you're telling us. How do you know that? Obviously, what is your name? Let's get a phone number. Are you personally observing this? Is somebody telling you these things? Yeah, there's probably a lot of questions I would want our dispatchers to ask. They don't always do, and they're not necessarily trained to do.
Yeah.
Their job's different.
Yeah, I mean, there may be a real some training needed for some of these dispatchers to understand the legalities of what we're looking for to collect the data we need to have a strong case. And although it seems like a tall order, it really isn't that hard to figure out. Hey, here's 5 additional questions to ask people. And we'd back up a little bit. Since we're on this topic, let's talk about, and then we're going to go back to I'm guessing what he's the second part of that question. But before we go to the second part of the question, maybe we should cover just quickly, briefly, if anybody hasn't heard the previous podcast episode, some reliability regarding the type of informant that you have. And I guess we can start at anonymous tipsters, what that means, and then go from there.
Yeah, that's your lowest. So a truly anonymous tipster is somebody we have no idea who this person is, and there's really no reasonable basis for us to be able to find out who they are. A truly anonymous phone call or anonymous letter or something like that. As far as reliability, those are very unreliable tips, because we don't have any way to assess the trustworthiness of the person, first of all, and we don't have an opportunity, unless they tell us what is their basis for knowledge. So they tend to be very unreliable, and we do get a lot of anonymous tips. Their general value is just to kind of point us in the direction of an area that we probably should be looking. Very, very infrequently will an anonymous tip, the content of an anonymous tip, be the sole basis of being able to stop someone or search them, or definitely arrest them. But there have been a couple of Supreme Court cases dealing with anonymous tips, but that cut both ways. Florida versus JL was an anonymous tip about a handgun. That was not enough for a stop and a frisk. Versus Alabama versus White was an anonymous tip about drugs being in a car, and the court said that was enough. The tip by itself was enough to stop the vehicle. So anonymous tips are your least reliable. Then up from that would be your criminal informants, and again, these are people who have a known past of criminal involvement. There generally has to be some kind of corroboration of the information that they give us, because there's an inherent reason to at least question their truthfulness. Confidential informants.
I'm going to go back for a second. Do they ever look at the motivation of somebody when talking about source of information?
Motivation could, I guess, go towards the trustworthiness of the person. If the motivation is somehow nefarious, that could certainly call into question how truthful this person is being about their allegation. But just because the motive could be a bad motive, doesn't necessarily mean that what they're telling us is not true.
Mm-hmm. And we talk about confidential informants. Things that courts will consider is, was this person on payroll? Were they being paid for the tip? Were they motivated to that? Were they the opposite drug dealer? Do they have some kind of underlying reason to fabricate a story? And I often tell people in class, like, let's call it a hot domestic. I mean, people will just say just about anything in a hot domestic, or if they're trying to save their own ass in a situation, does it mean that you can inherently trust it? You're going to have to investigate.
Right. Yeah, I think the person's motive for being untruthful could certainly would be something to consider in situations like that.
Okay. Yeah. So next up from criminal informant is what?
Well, confidential informant would be right above a criminal informant, at least slightly more reliable. But one thing we would definitely ask is, are they being paid? That tends to incentivize their truthfulness. Do they have a track record? So again, a confidential informant, let me explain what that is first. That's somebody we know who they are. We know the identity of this person. It's just someone who's wishing to not get involved in the criminal process. I mean, they're probably not willing to testify in court. That's what I mean by a confidential informant. And since they're not available, or they're, at least at this point, we don't believe they'll be available for cross-examination, for example, we would need to corroborate some of the things that they give us. We can't just automatically act on their word, but they can be just as reliable as a police officer or a concerned citizen. It's just the fact that they're not going to be available for court that requires a little bit more corroboration on our part.
Because under the Constitution, you have the right to call your accuser before you. Isn't that correct?
In the trial component, not necessarily in a pretrial motion like a motion to suppress evidence, right, but definitely in the trial. If part of what the confidential informant goes to proving an element of the offense that they're being tried for, then the defendant absolutely has a right to have that informant on the stand to cross-examine about that. Yeah, so absolutely.
Okay, next one up from confidential informant
would be the everyday concern. I call it a concerned citizen. This was the person I mentioned at the beginning, the guy or the girl that calls the police, just calls 911, whatever, reports what it is that they see or hear, what somebody's told them. We are allowed to believe they're being truthful. At least they believe they're being truthful. Mm-hmm. We would still need to investigate unless we have a known reason to question this very particular person. We are allowed to believe they are being truthful.
Cool.
And at the top of the list is other police officers, the folks that we know are police officers. We are allowed to believe they're being not only truthful, but that their basis for knowledge is generally sufficient as to what they're alleging.
I'm going to back up here a little bit, and this is a topic that is discussed here. Is there any difference between a unnamed citizen informant versus a named citizen informant? So, and this is something that'll help people in the field. A woman runs up to the car and says, "The gentleman down the street just pointed a shotgun at me." Now, after you go and you see the shotgun, he says, "He threw it under the car." It's actually a case out of Jersey City. That's why I'm citing the facts around it. You go there, the guy's outside, and there's a shotgun, the way she described it, laying under the hood of the under this car in the street where he hit it. But they turn back around and she's gone. She wants nothing to do with it. She took off. She just reported to the police. And what they did was they actually, the court said you had probable cause to arrest him for the offense. They did not, and he later got off on technicalities. Here's two technicalities they got off on. One, the cops did not tell the same story on the stand 2 years later. And two, and by the way, that could have just been a luck of the draw. I'm not here to criticize or point fingers. That maybe, 2 years, a lot of factual information is a little different. Maybe these guys didn't give a shit. Maybe they were, some of the more concerning people that we work with at times. And the second part was because the court said she had the right, the defendant had the right to accuse to confront his accuser and cross-examine them, and that woman was unavailable for court. So they essentially dismissed the charges, or he won trial. I don't know if it was dismissed. I think he won trial on those premises, on those grounds. But we also had a similar story where we had a guy working in a methadone clinic. And at this methadone clinic, he's worked off duty here for several times. And he's recognizing the same people that come in for the methadone treatments. And a gentleman walks in who he's seen on several occasions and says, "There's a guy out there outside. I just watched him do a drug deal. He's wearing a plaid shirt, gives a good description. The guy, he goes, it's doing a drug deal. He just actually tried to sell me his methadone. So the cop walks out and he does a little bit of investigation, like a Terry Frisk, but the court said the second that guy walked in and told you that he was out there selling the methadone, you had probable cause to arrest him and search him incident to arrest.
I agree 100%.
Mm-hmm.
I actually do a scenario in my class very much along those lines, your methadone scenario, to illustrate this point. And so either in the shotgun case you mentioned or the methadone case, what that informant, the fact that the informant is named or we know this person is really not relevant, because of the content of their tip rose to the level of probable cause that this person was possessing the shotgun or brandishing it, or whatever it was, or that this guy has drugs in his possession right now. We're allowed to believe these people are being truthful. They have incentives for being truthful, because we could arrest either of these informants for filing a false police report or something to that effect.
Yep.
If we were able to prove they lied, not that they were wrong, but that they were lying about what they told us.
Yep.
Now, for the shotgun case, we didn't need her in court for the probable cause basis, but I'm assuming they needed her to prove one of the elements of the brandishing offense or the possession offense that this guy was subsequently charged with. So that's why that defendant was probably acquitted, because she wasn't available for that purpose. But for the basis for the stop or the arrest, we don't need that informant at all in court. I can testify as to what he or she told me.
Yeah. And by the way, police often believe that they have to prove cases beyond a reasonable doubt right in the street. And that's not actually the case, man. So you want to collect data and do a fine, thorough job. But again, and you want to make it a strong, solid case. But making subjective judgments on how it's going to go in court as a police officer is actually not your job. Your job is to collect all the information and enforce the law and establish probable cause. That's really your job.
And a lot of evidence can be collected post-arrest. I mean, arrest can be an investigative tactic in some of your cases. So we're not trying to prove beyond a reasonable doubt on the side of the road.
Yeah. Okay. The second part of that was, I think what he's trying to get to is, when is it enough? And this is a very broad question as I play it in my head. When's it enough to see something and then that creates an investigative detention? And I'm going to just preamble this on a quick side note, where if you're talking about pedestrian stops and you had a pedestrian violation of pedestrian traffic law, just so you're all aware, that would be enough for an investigative detention where you could compel identification, because you could issue a summons for the violation. So on a quick side note, a lot of people don't know that. And guys and girls won't enforce that because they're afraid. And then, you go to the inner cities and they're enforcing that shit all day because they're coming up with great stuff. I mean, people are still going to have to get around when they're really, really wanted, or they're, they know that most cops aren't going to engage folks on a foot to, outside of a motor vehicle stop or a service call. So when you do, you catch people off guard, and the results are phenomenal. I mean, they're really great results, unbeknownst to a lot of people. So you would have that so if you see somebody thinks acting strange and they happen to jaywalk or walk against the crosswalk, the signals, or dart out into traffic and cause some kind of safety concern, whatever your law regarding pedestrian traffic in your state says, you would then have the authority to conduct an investigative detention similar to a traffic stop, right?
Oh, yeah. Yeah. But your focus is going to have to be on the violation of the law if you don't have the RS of the other criminal activity. It's just like a traffic stop. Yeah.
Right. So it's almost like a pretextual pedestrian stop.
Exactly what it sounds like to me. Yeah.
Yeah. Now, what, and again, it's such a broad question that I think we could maybe just provide a couple examples of what would be enough to stop somebody and compel ID. And I've got a few, but I'm going to give them to you first.
Well, it is a
very broad
question. And I guess I would start out saying that reasonable suspicion is not a high standard to begin with. I mean, probable cause, what it takes to get arrested or to get a search warrant, is also not a high standard. The Supreme Court has made that clear in numerous occasions, that probable cause at its lowest level doesn't even necessarily have to be more likely than not. They said that in Illinois versus Gates and several other cases. So it's a relatively low standard, and we all know that reasonable suspicion is lower than probable cause. So to be able to stop somebody on the street, it doesn't take a lot, but it has to be something specific. And an excellent illustration of this concept of reasonable suspicion, although the term is never mentioned in the case is Terry versus Ohio. That there clearly was no crime when Detective McFadden stopped Terry and the other two gentlemen that were with him. They had not committed a crime, but their actions that he observed, an experienced police officer observing those actions, it was reasonable for him to think that criminal activity was about to occur. They were either involved in a conspiracy at that point, or they were about to do something criminal. So that's really an excellent example. And the case lays out the facts very clearly as to what happened.
I would agree. I think Terry v. Ohio is the quintessential example of what you're looking for, and try to take that and apply it. And the only way to really know what were good factual cases where this was authorized is to read case law, man, because you're going to try to collect as many circumstances as you can and try to apply to the things you have in the field. And I don't know if you agree with this, Zach, and I think about this often when I write case law. And you could disagree. I mean, we're certainly colleagues, and I consider us both professionals, even though I hold you at a higher regard in this realm. I'm a far better lover, I'd imagine, than I don't know. Maybe not. Maybe you're just but no. I tend to think Terry v. Ohio is probably the most important case that police officers need to familiarize themselves with overall, by hands down.
Of knowing the facts of the case, I would agree 100%. Now, a lot of cases like Miranda versus Arizona, you don't need to know the facts. You need to know the rule that came out of it. Terry, I think you should know the facts of Terry. Yeah.
And I think Terry applies to how many cases that we look at as cops. I mean, I always tell people, if you want to start at a place to search your state's case law, run a search against Terry v. Ohio, pull the 290 to 1,000 cases that they've had to cite Terry, and you're going to get a real good understanding of a lot of things regarding what we do as cops, and especially proactively. They're always citing Terry and the things that we kind of talk about when it talks about Fourth Amendment search and seizure, namely for patrol division officers. Would you agree with that, or is that crazy to say?
Yeah, Terry is definitely a great case for those, and a couple other ones that United States versus Socolow is a good reasonable suspicion case. These are cases where the court really dives into these concepts of reasonable suspicion and what it means. Alabama versus White, Florida versus JL are some really good reasonable suspicion cases. The Glover case recently, not so much. Mm-hmm. Yeah, I would definitely start with those and read the facts and what the court says about the facts and why all of those cases except JL, the court found reasonable suspicion.
Let me jump in here and just say this. We have a reasonable suspicion checklist. It's really mainly a lot of times used on a motor vehicle stop. If you are a law enforcement officer, you have a privy to having access to that. It's found in our Street Cop Training Facebook group. It's a private group for law enforcement. You could email streetcoptraining@gmail.com, but you'll have to email us from your government email address or provide identification to confirm your identity. We are not handing out our resources at free will to everybody who requests it, because it's not that it's anything illegal. It's just that we're using it as a resource to train police officers to fight crime, and that's what it's used for. So it could be a little differently, but what I always try to explain to guys to start and really build the foundation is reasonable suspicion is knowing what's normal and saying, is this normal? Does this make sense? Is what's happening here normal of somebody who's not doing something wrong? And I tell people, when you leave this training session, you want to know what normal is, go turn your rear radar on and pull people over doing 11 over the speed limit. And when you pull them over, tell them you're not giving them a ticket. They'll generally calm down and relax from that point forward. If you took those people out of cars, which I'm not urging you to do to test run this thing, but if you happen to take those people out of cars and ask them about where they're coming from, where they're going to, a purpose of trip, relationship to people in the vehicles, you would find that it all makes sense. Passenger one knows, passenger two knows. They have a good explanation. It's in their GPS and their phones. Why they have this amount of money? Maybe they have a bank receipt, and there's no nervous behavior. They're very, very calm and sure. I'm not getting a ticket. I'll tell you anything you need to know. And then the latter. Then you find yourself in a situation where none of this makes sense. There must be something weird going on here. And again, please, if you're listening to this, interpret as I'm trying to give you a basis understanding of how to know or discern the difference between something that's non-criminal versus criminal. I'm not saying a violation versus a non-violation. I'm talking about criminal circumstances versus non-criminal circumstances. A guy standing in a crowd, maybe watching a cheer routine of Pop Warner cheerleaders, right? And his daughter, and he's filming the cheer routine with his cell phone, but his daughter's there, his wife's next to him, and his kids are holding on to him and they're playing, and you pay attention, and he's clearly the dad of this girl. It's very different than a gentleman who's on the other side of the field who is recording Pop Warner cheerleaders, who is recording it and kind of has sunglasses on, maybe a hood over his head, is trying to keep a low profile and seems to discreetly be recording this. I haven't seen any engagement with anybody on that Pop Warner cheerleader team. And we can conclude that this dude is up to no good. Or you'd at least try to come to that. And again, like Zach said, the prerequisite that you need to initiate an investigative detention, the question is, what law is he violating? Number one, do we have enough here? And number two, just so everybody knows, when you have circumstances like this, even the most liberal courts don't like people hunting children or recording children. So, it's very different when you think about what's normal, what's not. And that's really the name of the game, how to be a cop overall. So would you agree with that? Do you want to elaborate on that any further?
Yeah, I mean, just by spending a little bit of time observing people in your daily environment, you develop a baseline of normal behavior, not normal, non-criminal, everyday behavior. And just at one point, I guess I wanted to make about this, how specific of an offense do we have to be suspicious of before we can stop the person? Meaning, do I have to point to a specific violation of the state code that I'm looking to enforce before I can stop the person? And the majority view nationwide is no. It's just reasonable suspicion of illegal activity in general that would suffice for reasonable suspicion. Now, there are some courts that I have seen that no, you need to pinpoint a specific offense that you're suspicious of, but that's not anywhere near the majority. So yeah, we don't necessarily have to say we think he is getting ready to do this particular crime, or he's involved in this particular crime.
Yeah, New Jersey's one of those states. We actually had a case where somebody was arrested because the cop knew something was wrong, told him one thing on the scene, went back and read the book later and charged him with another thing. And the court said, well, you didn't know what he was, the defense was, you didn't know what you were charging for. And the court said he knew something was wrong. Him misciting the actual statute wasn't an incorrect thing. He still knew he had to take action.
Yeah, there's a Supreme Court case, and it escapes me right now, but an unlawful arrest, meaning we didn't have probable cause for offense A, can be saved by having probable cause for offense B, even though the officer was unaware that B could be charged at the time. So I forget the name of the case. I apologize, but it's out there. It's a Supreme Court case on that.
Awesome. What else do we have? Anything else? I think we're getting close to the end here, right?
Yeah, I wanted to a post the other day I saw on the Facebook page just kind of made me think about something. It's about Terry Frisks, and it was a concerning comment made by an officer on there. I know you've covered this in podcasts in the past. The lawful basis for a frisk is first you have to have a lawful stop of the person. Then you have to have an additional reasonable suspicion to believe the person's armed and dangerous, depending on what jurisdiction you're in. But right. Reasonable suspicion they got a weapon on them. Not all stops have that second reasonable suspicion. Without both of those, you can't frisk someone, no matter how concerned you are for no matter how safe you want to be. You have to follow the rules. And just because I want to frisk someone for my safety, if I haven't met the two Terry prongs, then I can't frisk that person. And this particular officer I read his comments as endorsing it's just a minor rights violation. It only takes a couple of seconds to frisk someone. If that keeps me from getting shot or stabbed or whatever, I'm willing to roll that dice because, okay, I might get some evidence thrown out. Oh, if I get sued, it'll only be for a couple $100 and whatever. And those two statements are probably true. But it's also a federal crime to willfully violate someone's constitutional rights under your authority or under your color of office.
Willful misconduct, right?
You know you're not supposed to do it, but
that's
you
right.
do it anyway.
And again, I often tell people, look, police officers, if they do something, often, very majority of the time, it's not a malfeasance or a malicious intent to disregard the law. It's lack of training, lack of knowing any better. And it honestly, as uninnocent as it may be, it actually is an innocent mistake at times.
innocent in the fact that you don't have a nefarious state of mind. Yeah, it's for all intents and purposes a good faith, meaning you have good intentions. You just were somehow,
and you didn't know it was wrong.
right. Yeah, and that's perfectly fine. Criminal conduct, though, requires you to know you're not allowed to do it, but you're going to do it anyway. And it doesn't matter why you want to do it anyway. If you do it and you know you're not supposed to, that is a federal crime. And that troubled me. And I've heard many officers over my career say, well, it's just a minor rights violation, and if I get to go home safely, then I'm willing to take that risk. Well, you're essentially admitting that you're willing to commit crimes because you've been told you can't do it, but you're going to do it anyway. And not to mention, it violates your oath of office. When you took the job, you raised your right hand and you swore that you're going to follow the rules and uphold the Constitution, and this is a constitutional issue. So I just wanted to throw that out there.
I'm going to jump in here real quick and add one thing to this. This is how I open my training program. You've been to it. I open my training program discussing this myth. And again, in defense of some of these folks, it is not intentional. Often it's just a mistake or misunderstanding how the law is applied. And by the way, some places were taught this. That's how they thought things were. There is one way to fix this. If you do want to pat frisk people, you can achieve this, and you just have to take one little piece of the equation and add it in, and that's ask for consent. And it's not a hard, so it's not hard to establish consent to search somebody. Merely asking somebody, would you mind if I check you for weapons, and following that scope and having some tactical ground, understanding how you're going to do that and understanding how to document some of that with the response unequivocal, or whether it's body language, showing submission, they put their hands on the hood of the car or raised their hands and turned around, looking for an unequivocal verbal response. What your state said was good or not, this will satisfy it. You want to be safe? I agree. I think you should be. Just ask. Right. Hey, you mind if I check you for weapons? And by the way, here's a crazy one. If somebody's carrying a weapon and you ask them to check for weapons, they're probably going to reach and try to go for that weapon. And at that point, you would have the ability to maybe intercept their hand and conduct your Terry frisk. Or they might take off running on you, which now turns into a full-blown arrest if you had a lawful investigative detention for the most part. So, nobody's advocating don't be safe. What we're saying is be safe, but be legal about being safe. And you can be, and it's not hard to figure out.
Yeah, and not to make sure that there was no confusion what I was saying. The way I interpreted this comment was I'm going to do it no matter what. Mm-hmm. I may ask, and he says no. Well, I'm going to do it anyway, and that's where the serious issue rises up. If you're that concerned about your safety when you're interacting with people, and you're willing to violate the law in order to be safe, then my suggestion is avoid the contact in the first place. Just don't
find another position,
leave,
Yeah. And listen, we're trying to, and I imagine for the people who maybe police critics hearing a podcast like this, I mean, guys, if you can't tell what we're trying to do, we're really trying to begin the process of really unballing up everything that's been kind of and it's a big task, folks. And all we can do is do our best in the time we have allotted to us here on this earth to try to dismantle all the myths and provide clarity where police can perform lawfully, comfortably, and legally in the field, and citizens can have a more comfortable feeling knowing that the police know what they're doing, know what they're talking about, and victims get justice and criminals get what they deserve. That's really the push of this company, especially these podcasts, when trying to help clarity. People understand clarity, and you see the general concern with the messages we got. We got cops who want to do stuff and just want the answers of how do I do it legally? So this person that he's talking about is generally a very, very big minority. I mean, we have most police officers. I was given a credit. We have one of our attorneys we were speaking with on the phone, and I'm not talking about a legal attorney, he was a trademark attorney, and he looked at our stuff and he said, the one thing I'm most impressed about with you guys is that how many police officers will pay out of pocket to go advance their career when there's no ROI essentially other than the knowledge of them performing. There's such good people that they recognize that they have not been served well with the training they've received, and they spend their own money, even on these meager salaries, to go out and get the training they need to perform this job to serve the public well. And I never forget when he said that. I said, yeah, it's crazy, man. I mean, literally cops will go out of pocket for professional development and have no ROI other than knowing the job and maybe something in the future. But very contrary to like maybe private business where you're going to go and learn at this workshop how to do this marketing thing. And when you're done with it, you're going to get 7% return on your marketing strategy. It's going to equal, you spend 5,000, it's going to equal 22,000 in return the following year. So it makes a ton of sense. These guys are literally and girls are struggling to understand, and we are trying to help ease that struggle and give them the clarity they need. And it's absolutely nuts to think of the things that we're actually doing as a law enforcement training company. And on top of it, with humility, kindness, caring. I told my wife this morning, we were talking about our street cop party that we're going to be having at my at the Casa. And I said, she asked me about this person. She goes, well, he was very nice when I met him. And he reminds me of this guy. I said, yeah. I go, Court, these people that we have collected as a group here of instructors and even our office staff are the best people I've ever known in my life. I mean, you just think about it. We not only are these the most professional police officers I know, but I just character-wise, I've never met a better group of folks than the folks that we work with. And Zach, I don't know who you've met so far, because obviously we're all over the country, all of us, but I mean, everybody's just such a good person. It's just crazy.
I've talked to several on the phone and had conversations over electronic conversations. Everybody has been very professional. And you can see that in the posts that some of these folks make. You can just get a sense of their personalities, and everybody's here for the right reasons. I mean, we are a profession, and we should be striving to be professional in the way that we conduct our business. And I wanted to mention the folks that do pay out of pocket to go to these classes. They should be recognized and commended for doing that, because they're probably also in agencies where they don't get paid a lot to begin with.
Yeah, dude, I'm serious. And by the way, like on a quick side note, that recognition, you could even find it in yourself, just a self-recognition of saying, you know what, I am investing in myself. I'm going to spend this money. I'm going to be the professional person I thought I'd be, because we know that this profession is not designed to be fair. And it's just the system's not designed that way to reward that. So if you're looking for recognition, you may not find it. And that could be a very deep struggle that you go down that road. So self-recognition of knowing that I'm a professional, I'm investing in myself. I don't care what other people think. This is who I saw myself being, and this is who I will become. So, self-recognition is probably the most important thing. People will say to me, okay, so we'll have people come to the office, and, people who are new here, maybe applying for a position, like, the things, or we have new instructors, like, the things you've done, they're amazing, da-da-da. And I'm like, I don't hear a lot. Because I'm so ingrained in this theory of, I know what I'm doing. I know what I've came to do. I don't hear the accolades, and I don't hear the negative comments. So if you can find yourself in a place where you ride right down the middle of it, you can, hey, thanks for the award, or I understand your concern, or this person may feel this way about me. Both are unaffecting you at some level. It's a real nice place to be in, because it helps you focus straight ahead. And for those of you who are taking the training, you are probably focused straight ahead on what you saw yourself becoming, and maybe picking yourself at some point. You don't have to wait till they say, you're going to go to this training in 3 years. If you think you need it, go take it. The ROI on your professional development is astronomical. And, we see that. I mean, why do you think it's the most popular training in the country? And I'm not saying other people don't have value. It just is. Because the word of mouth. This is great. There's other instructors, other companies who do a phenomenal job. I have a lot of relations with other companies. They do excellent work, and their programs are regarded as the same. There's not many. Maybe 10% out of the 100% that are out there are actually, enjoyable, practical. I think every class has a little bit of value, but I've been to training courses that were just like, oh my God. Yep. Why is this person talking? So when you can know and understand that what we're trying to do is admirable, and you are taking full advantage of the products that we have to offer, it's not a sales pitch, folks. It's the real deal. And there's a reason why Street Cop training will be regarded as the go-to for a majority of police trainings as we continue to progress and grow. Now I think we're circling right around 20 instructors. So we'll probably teach 20,000 cops this year, which is phenomenal. So we're excited about that. Anything else before we wrap up today?
That's all I got.
All right, listen, me and Zach Miller, We'll be back here next week, minus any major catastrophes or technical difficulties. If you have a question, we could probably only answer one or two if it's that dire and you have no understanding of it. Zach and I will probably pick something at random that we think is probably the next thing that we can talk about that will serve you the most value. I appreciate everybody's continued support. We couldn't do it without everybody. We know that we're appreciated as well. Without further ado, streetcoptraining.com or streetcop.com. We have the conference coming up. If you want to take police training that we offer, check out the website. We have a full list. Zach Miller's training, constitutional policing. Very limited seating inside of that. I think you're almost sold out one of your classes. I don't want to go into too many details here, but his classes sell out. You don't want to waste your time and pontificate on whether or not you're going to take this. It is one of those life-changing careers. I've said this before. The first time I sent Jade a video something, she called me halfway through and she goes, "He's very good. There's nothing. You don't have to change anything here. He's very, 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 very good." We don't have those acolytes very often. If we get that and somebody's on their first class, we spent some time with them usually and they develop their program. And then they come out after they've been trained for 15, 20 hours by us and they do a really nice job. But for somebody to be as raw as you are with some practical experience and have no input from us at all and deliver such a great product, I couldn't be more thrilled that you're here with us. And we have a friendship and you've decided to be a legal advisor for literally no fees to the law enforcement community. And I'm sure that it'll return to you tenfold at some junction.
I'm sure it will.
Yeah. So, all right, without further ado, Zach.
Thanks.
All right, see you.